2190367. This is Progressive Marathon Insurance versus Marshall Neighbors. The matter is before the court, set on for a status scheduling conference. The court did receive a document that has been offered as defendant's answer in this matter. Your appearance for Progressive, please. For Progressive Insurance, your appearance at this time. All right, do I have Marshall Neighbors?
Yes, sir, I'm here.
All right, good morning to you, Ms. Neighbors.
Good morning,
I'm
George.
looking to see if the attorney is here on this matter, so I'm going to come back. I'm going to come back to it in just a moment. Today is a scheduling conference, and so I'm likely to set up a schedule regarding this matter. But I'll come back to you shortly, ma'am.
Yes, sir.
The court now calls case number 22195662. This is Charles Hurt versus Willis Odoms. The matter is before the court, set on for a pretrial conference or except for a general hearing today. Your appearance for Charles Hurt. Do I have Charles Hurt on the Zoom?
Yes, yes, you do.
All right. Good morning to you, Mr. Hurt. Are you represented by counsel this morning, Mr. Hurt?
Good morning, Your Honor, and not this morning.
All right. Thank you. Counsel, Mr. Olin, your appearance at this time, please.
Matt Zemieski on behalf of Mr. Oden, Your Honor.
Your P number, if you will, for the record, counsel.
74406.
All right. Thank you, Counsel. Good morning to you. Looks like I've recorded the filing of the defendant's answer regarding this matter and accordingly set it on for a status conference hearing. I also note that there is the filing of the defendant's motion for an order permitting discovery. It is usually, of course, at this juncture that the court would consider granting this. By you filed your motion, of course, just for Mr. Hurt's awareness that in the district court, discovery is only allowed by order of court. Has there been any discussion between the plaintiff and defendant in this matter in terms of getting to the heart of the issue at this point, counsel?
Your Honor, Mr. Hurt is representing himself. In the last few weeks, we received a few phone calls from someone from a legal clinic that was, I guess, just trying to be a liaison and try to figure some things out. I've not spoken directly with Mr. Hurt. As set forth in my motion or my answer to the complaint, it looks like a lot of the stuff that's being asked for is stuff that I don't know is necessarily can be provided, given that this is a third-party lawsuit, not a PIP lawsuit. I was going to ask the court today for discovery and also for Mr. Hurt's contact information, so he and I can discuss, what I think there are the issues in greater detail.
All right. So, Mr. Hurt's basically what is being talked about here, of course, is that you brought forth a claim that would have to be litigated. Both sides have an opportunity to engage in that process. And part of that process is for the court to allow the next step in this proceeding, and that's the step that is called discovery. That allows parties on both sides to pursue information, to send out requests for production of documents, to send out interrogatory sets of questions, and to otherwise request information that the respective parties are required to turn over based upon the court rules. So two things are going to happen today. I'm going to set forth a scheduling order in this case. That scheduling order is going to allow for open discovery through the 14th of March of 2023. That date, March 14th at 9:30 a.m. will be the return date as well for the parties to come back to court. You're going to get an order from me in the mail. And that order that you receive in the mail is going to set the court date for the date as I've given it to you, the 14th of March at 9:30 a.m. In the interim, that period between now and the 14th allows the parties to exchange information, to request information, to issue sets of questions, and whatever might be allowed under the court rules that can occur during that process. Additionally, I'm going to put the parties in a breakout room so that they can exchange information and begin any efforts that might be available to try and get the case resolved. So that'll be the final thing that we do today. So you'll get an order from me in the mail in the next few days. That order will be an order allowing discovery through, again, the 14th of March, and setting the 14th of March as the pretrial conference date, right? So that's what I'm going to do today. Mr. Hurd and council, I'm going to send you a notification now to go to the breakout room for the purposes of exchanging information that might be necessary as a point of contact for trying to discuss whether or not this case can be resolved. You received your notification. I wish both of you well in the new year, and I'll see you on the 14th of March at 9:30 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Yep. I'm looking for counsel for Progressive Insurance. If you're here, counsel for Progressive Insurance.
I am here, Your Honor. Thank you.
All right, we're back on the record regarding 22-19-0367 Progressive Marathon versus Marshall Neighbors. The record should reflect that Ms. Neighbors is present in this Zoom. I did pass on this matter, knowing that counsel was somewhere in the wings. And your appearance at this time, Madam Counsel.
Thank you, Your Honor. Good morning. Tiffany Williams on behalf of plaintiff P number 74809 for the record.
All right, thank you, and good morning to you, Ms. Williams. And Ms. Neighbors, I know that you are still there. Say good morning to us once again, if you will, ma'am.
Yes, good morning, Judge.
Good morning to you, sir. All right, so I set this up because I did receive an answer to the complaint that was filed. It's in a one paragraph sentence. It says, it says, I'm opposing a lawsuit from Progressive in the amount of $9,576 due to hardship. I would like to know other payment options. So it seems to me that there, at least it sounds like there may not be a real dispute regarding the underlying claim. Mr. Neighbors is saying that, at least from that answer, it seems that he's saying that he's looking for some process by which he could make payments on this and get it resolved. Is that what you're saying, Mr. Neighbors?
Yes, sir. I'm Miss Neighbors. I am a female. Yes, sir.
I am sorry, I said Miss.
No, you totally
All right.
fine. You're fine.
Thank you. Thank you. I really do apologize about that. I hate to
No,
get
you're
that kind of
fine.
stuff. Be surprised how many times people refer to me as Miss Coleman. I tell them with the beard too. Don't all right. So what I want to do is I want to take a moment to start with placing the two of you at a breakout room. You might be able to get this resolved. Nobody can force that result, but if the position that Ms. Neighbors is taking is that this is not really a disputed issue, but she's just looking for a way to get it resolved, maybe the parties can talk about that and see if you can drill down on that particular direction. I will be here for you to come back in. If you're not able to reach a resolution, then come back in and court will direct the case forward from that vantage point. You're receiving now a notification for a breakout room from me. So go right ahead, and then I'll await your return.
Thank you, Your Honor.
The court does call case number 22-19-8219. This is LBNB Funding LLC versus Cynthia Jenkins. The matter is before the court set on for a status and scheduling conference. The court has received the answer of the defendant to the complaint that was filed in this matter. The complaint in this matter alleges damages of $1,717.86 for LBNB funding, please.
Good morning, Your Honor. Nafjat Francis on behalf of Plaintiff's Attorney of Record.
All right, thank you, Ms. Francis, and good morning to you.
Good morning.
Good morning. I'm looking for Ms. Cynthia Jenkins this morning. Say something to me at this time, please.
Good morning.
Good morning to you, Ms. Jenkins. As I indicated, I received your answer in this matter. And one of the principal things you said is that you don't know who LBNB funding is, and that you'd have to look at the contract regarding validity. This looks like a dead situation where whatever obligation it was, in the ordinary course of business, Credit One Bank transferred this debt to LBNB funding. Does that make this more familiar to you or less familiar to you, Ms. Jenkins?
Yes,
Judge,
she explained it to me because I didn't know what it was, but when we went into the breakoff room, she pretty much advised me of the debt. The only thing now that I'm remembering, I never got a total on the debt when we went into the breakout room.
Got it. All right, I didn't know you all had been in the breakout room. I was getting ready to send you there, so I'm so glad, Ms. Jenkins, that you said something to me. All right, Ms. Francis, update me, please.
Your Honor, we did speak in the breakout room. We were able to come to an agreement. We are going to enter into a consent judgment for the full balance, which are the damages of $1,717.86, plus the court costs and statutory $75 attorney fee. I unfortunately don't have the filing fee or the service fee to give a total, but it would just include those those additional amounts. And then we agreed to let me find her, sorry. We agreed to $40 per month starting February 1st. And that would be for 3 months, February, March, and April. And then in May, the payments will increase to $100 per month until the judgment is paid in full.
All right, so you were telling me, Ms. Francis, that you don't have a exact total regarding what the judgment amount will be?
I was trying to find it in my file, Judge. I don't have the filing fee or the service fee at this moment. I'm just trying to see.
Okay.
I do have the service fee of $53.50. I just don't have the filing fee.
All right, very well. So Ms. Jenkins, is this your agreement that you'll agree to the entry of a judgment with the principal amount at $1,717.86 and the service fee of $53.50 and then the filing fee, which is typically in the range of $40 to $60. So the combination of those three totals would seem to put you just under $1,900 as the total judgment amount, and that you would pay that at $40 a month for February, March, and April, and then $100 a month commencing in May until the balance is paid off. Is that something that you've agreed to regarding this matter, Ms. Jenkins?
Yeah, I mean, I don't understand how the balance that I owe with one company went all the way to these other $1,700.
All right. Some of that I'm sure has to do with the contract provision that allows for the accrual of interest on the debt. I'm sure that has something to do with that. Did you all talk about negotiating some of that number down?
No, I didn't. That would be definitely an option for me because like I explained to her, I was caught in a situation where I was in an active bankruptcy paying $510 out of my check every other week for 4 years to find out when COVID hit, the courts weren't paying my the people that I owed, which they were taking out of my check.
Okay, they weren't dispersing it, you said?
Yes. And I do have proof where I can show you of that because this is my second people coming after me right now. I mean, everybody's coming after me, and the only people that seem to have got paid was the attorneys because they took $12,000 from me out the $25,000 and never paid none of these people. That's why I got out of the bankruptcy.
All right. So you never received a discharge or anything that would have discharged any debt, correct?
That is correct.
So let me send the two of you back on that. Counselor, it seems that you don't have quote unquote an agreement, and maybe Ms. Jenkins wants to see if there is room to compromise on the overall total.
I unfortunately don't have any authority to reduce the total. So Ms. Jenkins, we would be able to agree to what we agreed to, or we'd have to get a scheduling order.
Thank you, Ms. Francis. Ms. Francis, let me ask you if you know what the principal debt was prior to the accrual of the of interest.
Um,
Ma'am, Ms. Jenkins, how much money did you owe before coming to court? What amount did you know was out there?
Thought I had an outstanding balance of about $900.
Okay.
It might have even been less than that. But
I don't show any prejudgment interest being attached to this, Your Honor. So this would be the balance that was on the debt before we
Got it.
sued on it.
All right, so, you know, it sounds like if we go by Ms. Jenkins' position in this matter, it probably is doubled by virtue of the accrual of interest, and that's a significant consideration. So, let me ask Ms. Jenkins, because she doesn't seem to be ready to enter into the agreement, so I'll set some dates on this. But Ms. Jenkins, if they reduce this, your judgment is almost 1,900 with court costs. If this was settled for $1,600, would that be acceptable to you?
yes, sir.
All right, Madam Counsel, maybe you take it back to your client and see if that is acceptable for a gross settlement of $1,600. That is what's being offered by Ms. Jenkins. And I'll set a date in the near term just to see if anything can go forward there, and then I'll start setting other dates into the future. So that is the offer that is on the table. And what I'm going to do is I'll bring this case back. I'm going to bring this case back next week just to see if we can reach a resolution. If not, I'll set it up on a schedule in the case to be litigated accordingly. So let me give you, let me bring you back. In fact, on the 17th, next Tuesday. 1/17/23. That's at 9:30 a.m. And I'll take a look at whether or not you've been able to resolve it. If not, I can go ahead and set a calendar. Okay. So see you at that time. The date to both of you.
Thank you.
Thank you.
All right, the court now calls case number 22-189-373. This is Mohammed Alawiya versus Marzouk Obed, that's O-B-E-I-D. The matter is before the court, set for a status conference court, having received an answer to the complaint in this matter. Your appearance for the plaintiff in this matter, I believe that the plaintiff is improper. Your name for the record, please.
Muhammad Alawiya. Good morning, sir. My name is Muhammad Alawiya.
All right, thank you, Mr. Alawiya. Good morning to you, sir. Let me look at one other thing here. All right, and counsel for defendant in this matter, your appearance at this time, please.
Morning, Your Honor. Mark Estecchi, P46289, on behalf of the defendant Marzouk Obeid, Your Honor, who's present.
All right, thank you, counsel, and good morning to you, sir.
Good morning, Your Honor. Nice to see you again.
It's good to see you as well, sir. All right, I did see where there is where the answer's been filed, but I also note that there was a filing of a counter complaint in this matter. Looks like that was filed with the court sometime in October. And I see that you have a motion that you presented to the court asking for entry of default on the counterclaim. Is that correct, Mr. Bezecki?
Correct, Your Honor.
So is that because it looks like I don't see a response from Mr. Alawi on this matter? Is that why you're asking for the default, because of no response?
Yes, Your Honor.
Mr. Alawi, you didn't file an answer to the counterclaim. I don't have anything in the file. The law requires that you file an answer, or a default judgment could be entered against you. Tell me about that, sir.
I don't know I had to, because I'm not him any money, you know. I mean, I'm not him any money, so I don't know I had to.
All right, well, you definitely have, you're required by law to file an answer to that complaint. So you began this lawsuit, Mr. Alavia, and you're asking the court to grant you judgment for some $18,000 regarding a breach. It looks like a breach of contract. Is that correct, sir?
Yes.
All right, so what type of contract was that? What is it that you entered into, sir?
I did all the job before 5 years. His whole house, like to living in. He living in before 5 years. He no pay me more than 3,500. We agree to do it. The 2 floor and the basement. The 2 floor $18,000 without the basement. But he no pay me more than $3,000. After 5 years, so I'm like, oh, in the middle of the 5 years, I'm trying to get my money. He don't want to pay anything.
Okay.
So I'm taken to the judge now. All of a sudden, he starts saying that one is not correct, that one is not correct. But I'm not the only one doing all this job.
Gotcha. Okay, so and you indicated to me that this has something to do with a building improvement or a housing improvement or something, correct? You did home repairs or something? Is that what you're saying?
Yes.
All right, and your that item says that you received $3,000, but you never received the balance that you should have been paid. Is that correct?
Yes.
All right, so and it looks like all of this was to happen in 2017. Is that true?
Yes.
So why did you wait until 2022 to file your action?
I'm trying. I'm trying to get the money. All the time he's saying I'm not have this much money because I'm spent a lot of material. So can you waiting like 5 months? Can you waiting 3 months? Can you waiting 6 months? After this, we put it people in the middle to trying to get the money. He no answering the phone. He don't want to pay the money. In the end, I told him I'm take you to court. He said, okay, you can take me to court, but I'm not paying the money because this is a taking long process. He trying like to make this is late, how much he can.
All right, let me go. Mr. Lezecki, what is the nature of the counterclaim in this matter? It looks like this is a long relationship where there was at least a claim that some repairs were done in anticipation of payment. What is that counterclaim about, sir?
Breach of contract, fraud, and negligence, Your Honor, for the work done on the home.
And you filed that claim. I guess one of the things I'm wondering about is, well, why would your claims not be time barred?
Neither claims are time barred, Your Honor. It's still within 6 years of the statute of limitations.
All right, that's what I'm getting at.
Barely.
I'm sorry.
Barely.
Yeah. It's I'm counting on this. All right. So Mr. Alloway, and of course I wouldn't have to ask you that question if I had time to really sit down and take a look at this. And I didn't see a motion, but I wanted to ask a basic question because it's getting close to those kind of issues. So let me ask you, Mr. Alloway, are you planning on responding to the counterclaim in this matter? You're past the deadline. You said you didn't understand that you needed to do so. I'm willing to give you a little bit more time to respond if you're going to put something in writing to try and respond to the counterclaim. You going to do that, sir?
Yeah, I want to respond, yes.
All right, so let me start there. With regard to the motion for entry of default judgment at this time, I will deny the motion at this time, given the circumstances that set forth on this record. I will allow the defendant on the counterclaim. I will allow the defendant 21 days to respond to the counterclaim. So you got to put something in writing and respond to the counterclaim in this matter. And I'll set this matter for review. I'm going to set it for review about a month from now. So we'll be looking at coming back on this matter. One of the next step is for me to set a trial scheduling order. But I want to make sure that that Mr. Alawina wants to and will respond to the counterclaim. Otherwise, I will grant motion for entry of default in this matter in the normal course of business. So the next action date in this matter is going to be, I gotta put the 15th. Actually, let's go to 13th of February, February 13th. You have 21 days, sir, to respond to that counterclaim. You gotta file, put something in writing to respond to the counterclaim. If you do not, then you are in fact in default.
Thank you.
And a judgment will be entered on that default. The 13th of February, 10 o'clock a.m. will be the next action date in this matter, 2/13/23, 10 o'clock a.m. I'll review the matter at that time and set a scheduling order if that is the appropriate thing to do on that date. All right. Thank you, gentlemen.
Your Honor.
Thank
Your
you.
Honor. Your Honor.
Yes, sir.
For the record, I object, just because MCR 2.603D, he did not file a motion to set aside default judgment, Your Honor, or the affidavit of meritorious defense. And the only way to that the default may be set aside is for good cause, and also for the defendant to state a meritorious defense under oath.
Yeah, absolutely. There was not, to drill down on that pursuant to the court rules as it relates to entry of default. I don't see paperwork filed in that regard.
Had 24 days to respond since I mailed it back. It was certified mail back on 12/16, Your Honor.
And I do see that now as I go through the file. I do see that there was a default and a request for entry. The court has listened to the statements made relative to the nature of this case. It does seem to be a matter that has a genuine dispute. The excuse for not responding to the complaint is a little bit more difficult for court to grapple with. But Mr. Alavina said that he did not understand that he had the obligation to do so. I think that what has been set forth on the record is a sufficient basis for the court to reach the conclusion that at this point, the court will not allow the entry of the default judgment. And I deny the motion now for entry of default and allow the defendant 21 days to file an answer. If he doesn't file an answer, then default will be entered and default judgment will be entered. And your objections, counsel, are noted for the record.
Thank you, Your Honor. You have a wonderful day.
To you, sir. Good day to you.
Thank you, Your Honor.
Thank you.
All right, I have Neighbors and Williams back in the courtroom.
Yes, Your Honor.
All right, good morning again to you regarding the suffix 3861 regarding the suffix 0367. All right, and good morning again to both of you. Madam Counsel, talk to me at this time.
Yes, Your Honor, we were able to settle the case.
Ms. Neighbors, I see a chair with a light above it, but I don't see Ms. Neighbors.
You know, and I think she's at work right now, so she may have had to step away. And I don't mind waiting for her, obviously, to come back.
All right, so I'll come back to the matter in just a moment. Looks like Ms. Neighbors is back. Good morning
Yes,
again.
I'm sorry. I'm back. I'm sorry.
I see you there working. We're considerate of that. It's been indicated to me that the parties, after talking about this, have found a way to reach an agreement regarding this matter.
Yes, sir.
Is that correct, Ms. Neighbors? All right.
Yes, sir.
And so, what is the agreement, Ms. Williams?
Yes, Your Honor, we're going to enter a consent judgment in which we will satisfy the judgment once the defendant pays $8,000. She's going to make monthly payments of $300 each month, starting on February 10th until $8,000 is paid in full.
Is that in fact the agreement that you reached in this matter, Ms. Neighbors?
Yes, sir, Judge.
All right, very well. I will indicate that the file has in fact now been resolved, and I will await an order in this regard, and I will sign an order upon its presented. You can go ahead. You can go ahead and begin to execute on this. That is, the parties can go ahead with the agreement. I know a payment starts in February. If you'll email the proposed order to me, I'll get it right back to you as well. It can be emailed to Carmen, C-A-R-M-E-N, Carmen dot, last name is Banks, B-A-N-K-S, Carmen.Banks@36districtcourt.org.
Okay, thank you, Your Honor.
Right, Ms. Neighbors,
Thank you.
if the consent says the stuff that you've agreed to today, is it all right? If Madam Council puts your initials on there as agreeing on the record?
Yes, sir.
All right, and I'll make sure that I won't sign it unless it says what you guys agreed to, all right?
Yes, sir, Judge. Thank you.
All right, I wish you well. Council, you can send that order on
You
in.
as well.
Thank you, Your Honor.
Thank you. Have a good one.
Take care.
Thank you.
The court now calls case number 22-193-861. This is Tracy Stevenson versus Tanae Hawkins. The matter is before the court, set on for a hearing. I think this is the first hearing after an answer, so this would be a status scheduling conference hearing. All right, do I have Tracy Stevenson or any counsel for Ms. Stevenson on this Zoom?
I'm here, Your Honor.
Thank you, Ms. Stevenson. Ms. Stevenson, are you represented by counsel today, ma'am?
Yes.
All right, where's your counsel?
He should be on.
All right, I see him working at it now. Just one moment.
Judge Coleman.
Yes, sir. Your
Good morning, Your Honor. Raymond Salom on behalf of the plaintiff. I apologize. I just got called into Wayne County Circuit Court with Judge Kelly.
This is a status conference for it.
Go ahead and deal with the circuit court matter, sir, and come right back to me.
Okay, I'll come back. Thanks, Judge.
And Ms. Stevenson, we'll come right back to you. Do I have?
Not a problem. I will wait. Thank you, Your Honor.
Thank you. Mr. Nay Hawkins on this Zoom?
Your Honor, she is, and I'm counsel for Ms. Hankins as well. Attorney Patrick Bakri, PH 4539.
All right, thank you, counsel, and I will, well, you heard what just went on, so we're gonna come right back
No
to this
problem.
matter.
Thank you.
Represent, Salome Williams as well?
Yes, Your Honor.
All right, very well. We'll come back to the matter in just a moment.
Thank you.
All right, the court now calls case number 19-240893. This is Starlene Bragg versus Ardina Hendrick. The matter is before the court, set for a hearing. It looks like there was a previous order that this court signed dated the 29th of November to enforce a post-judgment subpoena. And looks like there is an order of discharge that has been presented to this court. We'll see what that's about. Do I have Starlene Bragg on this Zoom? Ms. Bragg? Do I have Ardina Hendrick on this Zoom? All right, I'll pass on that matter. We'll come back to that matter in just a moment. All right, let me see if I have case number 22-185-305, Fox Point. Excuse me.
Your Honor, Your Honor, my name is Ardina Hendricks. I
gotta come back to you now. I'm on another case. You can't interrupt like that. All right, this is Fox Point Townhomes versus Jacqueline Lindsay. The matter is before the court on the following strike that, for an adjourned pretrial date. All right, your appearance for Fox Point Townhomes, please. Jacqueline Lindsay. All right, I'm looking for Jacqueline Lindsay. I'm looking for anyone representing Fox Point Townhomes. Look like Michael Beach.
I'm sorry, Your Honor. It looks like I was on mute. I was talking to myself. Good morning, Attorney Ashley Nonis on behalf of plaintiff. I don't think Mr. Munson is going to be appearing because we do have a resolution. I emailed it to Ms. Hunter this morning, but it seems like you may have gotten a new clerk. So I just forwarded it once you sent her email. So you should have that, and I'm going to mail the originals.
That sounds good. Yeah. There's someone that's temporarily with me as Ms. Hunter is on leave for a time. So okay. That's going to be using. So I will note that the file has been resolved, Madam Counsel, and I will await that order if you'll get it signed up and back to you.
Great. Thank you so much. Have a good day.
Clerk is saying to me right now, this is it.
Yeah, this one is good enough. She don't have to send nothing else.
Oh, you don't have to send anything else. She says she has. All right.
Perfect. Thank you so much, guys. Have a good one.
All right. Likewise to you.
My name is Ardina Hendricks.
I'm not on your case yet, ma'am. You cannot talk until I call on you. If I pass you, I'm going to come back to you. Okay. You don't have to worry about it. That's why I said I would come back to that file, and I will come back to the file. All right, just one moment, ma'am. All right, I'm back on the record now. Okay, yeah, we're back on the record regarding the case 19-240-893. That's Starlet Bragg versus Ardina Hendricks. I'm looking for Starlet Bragg. First of all, if you're here, Ms. Bragg, say something at this time.
Yes, Your Honor, I'm here.
All right, thank you, Ms. Bragg. Good morning to you. I'm
Good
looking
morning.
for Ardina Hendricks at this time. And I know that you're there. Say something now, ma'am.
I'm here.
All right, good morning to you, ma'am.
Good morning.
I signed an order for enforcement of a post-judgment subpoena, but then I received an order of discharge in bankruptcy under Ms. Ardina Renee Hendrick Moulton. And that order is dated the 5th of December 2022. Let me see what it says. Just one moment. It's a motion to a motion granting, order granting a motion to reopen the case under a Chapter 7 bankruptcy. So, Ms. Hendricks, you filed to reopen your bankruptcy that was looks like it was dismissed. But first of all, it says a discharge under 11 USC was granted to Ms. Moulton on 12/9/22. Do you have the listing of the creditors or debtors that were discharged,
Yes, I have a list of those creditors, and Starling Bragg is one of them.
Why did you send that to me? I have your, I have the discharge, but I don't have the list of those that were discharged. Let me ask you, Ms. Bragg, did you get something from bankruptcy court letting you know that a debt against you was discharged in bankruptcy?
No, Your Honor.
All right, so ma'am, how soon can you get your list of creditors that were discharged? How soon can you get that to me?
Well, I have a funeral today. I can get it tomorrow.
All right, so let's do this. Ms. Bragg, of course, if the bankruptcy court has granted Ms. Hendricks a discharge of this indebtedness, then there will be no further action that this court could take other than to close this file out. So significant to this is whether or not Ms. Hendricks received. Well, she received a discharge. The question is whether or not your debt is included on that document as discharged, because if it is, then there's nothing that you could do to collect on that debt if it was discharged in bankruptcy. So what I'm going to do, so ma'am, if you can get that to me, you can even email it. If you can get that to me, I will set this case back up for hearing on this Thursday. Can we take a look at that, because that's a crucial issue. If it's not discharged, then Ms. Bragg still has the right to go forward to try and collect in this case. But if it's discharged, that's the end of this case. So
Okay, well, I don't mean to cut you off, Your Honor. Can I, because I have a funeral to attend to today, and I don't have a way of emailing you the paper today.
that's okay, ma'am. You could, as long as you get it to me tomorrow, I'll set it up for a hearing on Thursday, and Ms. Bragg can come back and then I'll take a look at it and see what that document says.
Okay.
So if I give you an email address, can you do it that way, or will you be dropping it off tomorrow, or which way?
Dropping it off. I'll be dropping it off.
All right. So when you come to the court tomorrow, let them know that you need to drop a document off at Judge Coleman's courtroom on the 5th floor.
Okay.
All right, you understand?
Yes, I understand.
All right. So make sure you get that to me tomorrow. So I'm going to set this over for this Thursday. You come back into the Zoom this Thursday. And that's going to be at 9:45 a.m. So this Thursday, that is the 12th of January at 9:45.
Okay.
All right, so I'll see the two of you then. I'll see you on Thursday at 12 at 9:45 a.m. Come into this Zoom, and I'll address the crucial issue in this case of whether or not the discharge included Ms. Bragg. And if it did, then that's the end of this case. If it did not, Ms. Bragg will go forward to continue to collect under the judgment. All right. So good day to the two of you. I'll see you on Thursday.
Okay, thank you.
I don't think that I see Mr. Saloma back yet. We're waiting on him before we call that matter. Madam Court Reporter.
Yes, Judge. I see, it looks like, well, I see Salome, but he's on mute.
Yeah, he's in another courtroom. I see Mr. Hurt is back, and Mr. Zaluski. I know I messed that all up. I took a tab and I totally messed that up. So
I heard them all, Judge.
Back on the record regarding the suffix 5662, that's Hurt versus Owens. And I know the parties went out to speak on this matter. I think you're all set to go because I think I set up a pretrial scheduling order, unless you reach some type of resolution. I thought that this was just talking about exchanging numbers. Go ahead.
Your Honor, yes, Matt Zamiaski again on behalf of Defendant Odoms. We did send us to a breakout room. We have not reached a resolution today. We do have the discovery order and the scheduling conference or scheduling order that we'll wait to see from the court. I did speak with Mr. Hurt. We did exchange contact information. Mr. Hurt and I agreed that he does not have a stable or confident mailing address at this time. And I explained to him that I can communicate via email, but until there's an order or some effect saying that email is permitted by this court, that I'd have to use an address. So if the court would permit, I'm orally moving, and frankly, I don't know the court rule off the top of my head. I could look it up, but orally move for the court to allow us to communicate via email, and I would prepare certificates of service and an order to the same effect. But that's why I asked to come back, just so that the court and Mr. Hurt and I are all clear that that's how we'll communicate, because that's probably the best way of doing it for the time.
That makes sense to me, and the court rule would allow the same under your motion. Mr. Hurt, is that agreeable to you regarding the communication by email, sir? Mr. Hurt, I see that you.
There is one thing I would like to ask with that, Your Honor.
Yes, sir.
If it's to be able to, because currently I don't have a regular legal representation. If it would be possible, I would like to request or ask for a court representation or an appointed lawyer to be attorney to assist me in these matters.
On the appointment of a lawyer, that's only in criminal cases. Civil cases, we don't have a mechanism for doing that. You could check with the, I think there's the Legal Service Corporation and any of the agencies that might be around. I know it's a very, very limited resource, but you would have to reach out to various agencies around, trying to see if they have an opening for a lawyer to assist you in this regard. But because it's a civil case, we don't have any authority to appoint a lawyer. That's only in cases where people are faced with the potential of going to jail, and this is just a dispute about money. All right.
All right.
So,
Right.
not a problem. So I'm going to go ahead and set this up that the process and the parties can exchange information by way of email, and that will be just as if it has been sent by ordinary mail. That provision is going to be in the pretrial discovery order. So it's going to be a part where the court is going to order that a service of documents be allowed by way of email as a part of the course of this process. So you'll get that from me in the next few days.
Thank you, Your Honor.
Thank you, Your Honor.
Good day to both sides.
You too. Thank you.
Are you okay? All right, so we're back now on the record regarding the suffix 3861. That's Tracy Stevenson versus Janae Hawkins and Salome Williams. Various counsel have indicated their presence regarding this matter. Once again, Mr. Salome, your appearance, please.
Thank you, Your Honor. Good morning, Raymond Salome on behalf of the plaintiff, Tracy Stevenson.
Thank you, Mr. Salome. And again, Mr. Barry, is it? Go ahead, sir.
Yes, Your Honor. Good morning, Your Honor. Attorney Patrick Bahri, PH 4539, on behalf of the defendant, Tanae Hankins.
Thank you, counsel. Good morning to the two of you. And I know that various clients or defendants or plaintiffs are also present at this time. I did receive the answer, and of course, the matter is properly joined, and the court set this up as a time to get the status and perhaps set up a scheduling order regarding this matter. Your perspective as to where this case is at this time, somebody go ahead and weigh in and tell me what your thoughts are.
Your Honor, Mr. Sloan, would you like to
I'm
go?
sorry. No, go ahead. I'm sorry.
No problem. Your Honor, at the present moment, Brother Counsel and I have had some discussions on reaching a resolution. We've also discussed mediation if possible, if you had any recommendations for that. And hopefully we can reconvene sometime soon and possibly put something on the record. If not, then we'll have to go the other route.
Mr. Salome.
I would concur. The only addition that I would make is a little short discovery period before we mediate.
All right, so I'm glad to hear that the two of you have been exchanging and talking, and of course, passing this by your clients. I'm going to go ahead and I'd like to bring you back sooner, but I'm going to go ahead and set it up on a 60-day calendar, and that'll give you time to discuss, also time to drill down on any information that that you may need that may be in possession of the other party. So I'm going to go ahead and set this up and come back to me on the 14th of March. That puts us out about 60 days. Discovery will be open during that entire period of time. And provision number 6 on my order also will allow you to file motions and have them heard on the next action date. So you could file a motion, it could be heard on the 14th of March, and the requirements are quite simple. You only have to allow at least 10 days for the other side to respond to the motion. So if you file your motion and it gives 10 days for the party to respond, then the court will hear it on the 14th of March. Now, that does not preclude in the future if you want to file a motion dispositive or otherwise, but this is a situation where the parties look at it and say that one or the other say that there's something that I think resolves this case or non-dispositive, if you want to get it in front of the court right away. I've shortened the time requirements. Your motion, just make sure you give the other side, the opposing party, at least 10 days to respond and set it for hearing on the 14th. I'll hear it that day. Pre-trial date.
Your Honor, the 14th, I have a trial in Wayne Circuit. Is there any other day that week that would be possible for the motion?
I can move it. I can move it earlier to the 13th. We can move later in that week to the 16th.
That's when the trial starts. The judge has a blocked off Monday and Tuesday of that week, the 13th and the 14th. The rest of the week is fine, 15, 16, 17.
I can do it on the 16th. Otherwise, I'll put it in the next week.
March 16th would work for me, if that works for Brother Counsel.
That works for me as well. Thank you.
So I'm going to go ahead and set it at 9:30 on the 16th of March, and you'll get an order from me with the information that we talked about. It's a pretrial scheduling order. And when you come back on the 16th, if you've not gotten it resolved, then the court will engage with you to see if we can move towards that, and if some mediated process might be a way of doing it. The court is also willing to engage in assisting perhaps in mediating the matter to a conclusion, but if there's another party that we need to engage in the process, we will talk about that. Right? So I wish you well.
Yep.
See you on the 15th, and you'll get the order in the next few days.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Thank
Goodbye.
you. Bye-bye.
I'm seeing a last name Flowers on this Zoom. Tell me who you are and why you're here.
Yes, I was here for a driver while I suspended. I had court earlier, but I missed it.
Yeah, you're in the wrong courtroom. I don't handle that kind of stuff. Do you have anything that tells what the judge's name might be on that case, or?
Liz Sabri.
Sabri?
Yes.
Yeah, Leah Sabri. Let's find her courtroom number.
438. I can give them the telephone.
Okay, so it's courtroom 438. So you would do, if you were doing the Zoom, you do 360-438-000. I'm going to give you the courtroom phone number as well. So that phone number is 313-965. 2406. So the phone number to Judge Sabri's courtroom is 313-965-2406. The Zoom number there is 360-438-0000.
What's Zoom again?
360-438-0000.
Okay, thank you.
All right, and you make sure that you tell them that you were in Judge Coleman's courtroom, you're on the Zoom here, and we can verify that because they may be off the Zoom now, so you want to call the courtroom if they're not there on the Zoom and let them know where you were so that they can set you up a proper court date. Okay.
Okay, what's the courtroom number again?
The courtroom phone, the phone number?
Yes.
Yeah, that's 965-2406.
2406.
Yes, sir.
Okay.
All right. All the best to you, sir.
Good.